the statement by the representative of Council of Europe.
Thank you, Mr. Moderator. Excellencies, ladies and gentlemen, my name is Əhməd Şahidov from Azərbaycan Institute for Democracy and Human Rights. Today I want to talk about the independence and quality of the judiciary. The independence of the judiciary is certainly an essential principle which underpins what today is termed the state governed by rule of law in accordance with the proposition of the separation of powers as defined by Montesquieu in 17th century. As that great philosopher stated in his work, The Spirit of the Law, there is no freedom if the power to judge is not separate from the legislative and executive powers. So all would be lost if the same man or the same body of rulers, nobles or people exercised all three powers, that of making the laws, that of executing public resolutions, and that of judging the crimes and disputes of individuals. Any society in which there is no guarantee of rights or clear separation of powers is without a constitution. The principle of separation of powers, to which judicial independence is closely linked, is not accepted and understood in the same way in the various legal and court systems that exist in Europe today. Nobody could seriously deny, for example, that the judiciary in the United Kingdom enjoys a situation of total and perfect independence. And yet, it is the same system in which the person considered as being head of judiciary, the Lord Chancellor, at the same time exercised the function of Minister of Justice, Speaker of the House of Lords, and the country's leading judge. First of all, it should be observed that it's not merely the judiciary as a whole that has a problem of autonomy and independence, but each individual judge. It's for this reason that we may talk in terms either of the autonomy and independence of the judiciary or of the autonomy and independence of judges. Indeed, the systems of the different countries should seek to guarantee not only the independence of the judiciary in relation to other public authorities, but also the independence of the judge in relation to other aspects of economic and social life and even within the judiciary. The never-ending problem of the independence of the judiciary in relation to the economic and financial authorities may also be mentioned here. Another form of judicial independence is independence in relation to political parties. Europe finds itself divided on that question. On the one hand, one group of countries reacting against the tradition that obliged judges to be members of the party in power totally prohibit a judge from belonging to any political party whatsoever. On the other hand, the other systems, by contrast, prefer to regard the judge as an ordinary citizen who, as such, should not be deprived of the right to join a political organization. I should like to mention two completely new forms of independence. First, the independence of judges in relation to the media. The tendency for the judge's activities, particularly in criminal matters, to be given media coverage has recently assumed worrying proportions more or less throughout the world. The risk remains that the judge may be influenced in his functions by the press, particularly in the case of judges aspiring to a career in politics or even election to the higher judicial council. The last form of independence that I would like to mention here is freedom from ignorance. If the judge is ignorant, said Jean de La Fontaine, it's the robes that carry respect. If we want those robes to be worn by a judge who is respected by the people in court and entirely free in reacting his decision, the judge must have a thorough knowledge of the subject matter in which he is dealing. A well-trained judge is a more independent judge, I think. If we now take a look from this standpoint at the development of the law in post-Soviet countries, we are bound to observe that the transition to a democratic government has not always involved full acceptance of Montesquieu's doctrine on the separation of powers. Unfortunately, as a general rule, it must be said that influence of the executive authorities in post-Soviet countries is still too strong. I tried to summarize the basic principles and the crucial requirements for the exercise of a truly independent justice system. The judiciary is an autonomous body. It's not subject to either of the other state authorities. Public prosecutors should enjoy the same statutory guarantees as judges. Judges and public prosecutors are subject only to the law. Judges and public prosecutors should be appointed for life or for such period as is consistent with guaranteeing their independence. No change introduced in regard to the compulsory retirement age should have a retroactive effect. Judges and public prosecutors should be selected by public competition. The selection and appointment of judges and public prosecutors should be carried out according to objective and transparent criteria and on the basis of the professional qualification of the persons concerned. There should be no interference by the legislative or executive authorities in the selection of judges and public prosecutors. A higher judicial council should be established with responsibility for appointments, assignments, transfers, promotions, and disciplinary procedures in relation to judges and public prosecutors. This body should be composed of judges and public prosecutors, or at very last should include a majority of judges and public prosecutors. And finally, judges and public prosecutors should only be transferred, suspended, or removed from office in circumstances prescribed by law, and then only as a result of disciplinary finding reached by the competent body through the appropriate procedure. Thank you very much for your attention.
Sir, thank you very much for your contribution. I would like to underline